Yeah. Good morning. There was a slight delay in starting. As you would know that this is a common session for 3 of the courses I'm currently offering. The first course is what we call the Patent Law for Engineers and Scientists. So some of you would have been enrolled for that course. The other course is Patent Drafting for Beginners. Now, these two courses are specially designed for people who are serious about pursuing intellectual property as a part of their career. You could specialize as an intellectual property professional if you have a background in science or technology, or you just want to have a deeper understanding of how intellectual property works. We had designed these two courses. The third course is Managing Intellectual Property in Universities. So this is a common session for all the 3 courses. There are some questions that you have raised. I can see that there are responses. The live interactive session form has been filled, and you should be able to see that on the screen. So what we would do here is we would give you a general introduction on the courses, and you can see that these are the 3 courses. You can see that all these 3 courses have been offered in such a way that you can get some proficiency in these 3 subjects. So let me start with Patent Law for Engineers and Scientists first. The syllabus of this course is designed around the paper 1 of the patent agent examination. Patent agent examination is an examination conducted by the central government. It is the only examination that is conducted by the central government, which covers intellectual property rights. And clearing the exam would qualify you to become a patent agent. By becoming a patent agent, you can practice before the Intellectual Property Office. You can file patents, prosecute them, give advice on patents, and you could become in-house counsel or join a law firm or any department which deals with, say, broadly with research and development as well as intellectual property rights. So the career prospects are quite bright, and we can see that intellectual property, the field of intellectual property is a growing field, and India is catching up with its with other countries as well in this field. So there is tremendous amount of growth. You know that we are at presently living in a knowledge economy, and the only way in which you can protect knowledge is by having some kind of intellectual property right over it. So when I say protect knowledge, there are some kinds of knowledge which are meant to be shared and which are meant to be kept in the open, what we call basic knowledge. And there is applied knowledge or applied the products that come out of applied research, which can be protected by intellectual property rights. So, so these 2 courses, Patent Law for Engineers and Scientists, as well as Patent Drafting for Beginners, together are designed in a way in which if you complete them, then you should be ready. You will require some more preparation. For instance, we do not do any practice courses. There are quite a lot of past question papers, and some of them have been solved with answers. These are things which you will normally find in the market. So this course gives you an introduction to cover that, and I am confident that people can clear the course clear the patent agent examination course by taking these 2 courses and doing some practice tests. There have been many instances where people have written to me, professors from colleges who have taken the exam and cleared it in 2018. So there are multiple instances. So, so my general advice would be that those who are looking, even if you're not sure or certain, even if you're looking at getting some expertise in intellectual property rights, and you happen to be a person with a scientific or a science background, science or technology background, then these 2 courses will definitely give you a strong foothold in developing a career with some focus on intellectual property rights. We have these 2 courses are more focused on patent law because the other aspects of intellectual property rights like copyright, trademark, they are not directly material for a person who comes from a science background, because the work of science or scientific work or works pertaining to technology can be protected predominantly by patents. So when I say predominantly, there could be an aspect of copyright protection or trademark protection, but predominantly the work that comes out of, say, an engineering college or an institute which deals with technology is going to be patents. So that is why there is a focus on patent law in these two courses. So, and these courses have been now being offered for many years now. So we can tell you confidently that people who have taken this course have benefited in shaping their career and in becoming proficient in intellectual property rights. So there is quite a lot of feedback that we receive. You may find some of the feedback on there are YouTube videos covering interviews. You may find that, and if you are interested, we may be able to connect you with people who have already taken the past courses and also cleared examination. And as I said, some of the faculties in engineering colleges have cleared the exam and have become patent agent. The third course, I've grouped this together because they all pertain to intellectual property, right? And predominantly we are addressing students and faculty who are interested or who are already working in educational institutions. So that is why the focus is, I had a common session. Ideally, I should have had this on the first week of when your course started, but we had some clash with the dates and we were not able to get slots for all the three courses. Now, the third course, that is managing intellectual property in universities, it is designed for universities to have a system in place within their educational institution for managing intellectual property rights. Now, when we say a system, it goes beyond bare knowledge of patents, it goes beyond bare knowledge of intellectual property. It even goes beyond doing courses and becoming proficient in the law. A system means where we are able to identify intellectual property rights that may already be there in the university, do some kind of analysis to see whether this intellectual property, the subject matter can be protected by intellectual property right or not, then do a pre-screening audit, what we call, if it is entitled to a patent, how to do a patent search, because without search, if you file a patent, there is a big chance that it could fall foul of some prior art. Prior art, as you would know, is something that is already there in the public domain. Now, you need to understand that the United States last year has granted more than 10 million patents. They crossed the 10 million patent threshold last year. So when we come up with something, it is incumbent on us to do some kind of an audit or an analysis before we jump and file patents. So patent search is something which is a very critical tool, and how you employ the tool, there can be amazing results that come out of it. For instance, a professor, before he embarks into the research, does a patent search to know the portfolio of patents and even identify the universities which are doing that. He may get the gist of this by looking at comparative literature, say in peer-reviewed journals, to understand what others are doing. But patents define a different intent. Your research papers that get published in peer-reviewed journals are just indicators that some work is happening. Whereas filing a patent means that there is something that is coming out of a particular university which could have a commercial potential. Either the university itself wants to incubate a startup, which some universities do, or the university is interested in having a partnership with an industry player in developing this technology further, or the university is interested in granting this on some kind of a license, exclusive or non-exclusive. So this part is critical for universities to know that if you don't do a patent search, then you could be in a terrain doing work that has already been done before, which is detrimental for getting a patent granted, or you will not be able to find any white space because you didn't do an analysis before you embarked on the research. So patent search is something which is a part of IP management, and we strongly urge universities and educational institutions to focus on patent search before they do their filing. So if you get a report which says that, yes, this looks like it is inventive, it is novel, there is no prior art conflict, it does not map with any of the prior art disclosure, then you go ahead and file a patent. Now, filing a patent itself is not the end. You have to maintain the patent for 20 years, and you'll have to look at opportunities to commercialize it, to license it, or even to develop the technology further. So for all these things, we recommend that the universities require a system for managing intellectual property rights. Now, the system is different from knowing what intellectual property rights are, doing courses on intellectual property right. A system is a completely different platform for managing intellectual property. So This course starts with introduction to IP, and week 1 and 2, as those who have enrolled for this course, is on the basics of IP. In week 3, we get into how IP is managed in a university, and in week 4, we will be looking at the objects of the entrepreneurial function. Universities have an entrepreneurial function, and the entrepreneurial function of a university, and when I say university, I also refer to colleges as well. It's a broader term, an easier term to cover educational institutions which could be developing intellectual property right that can have commercialization potential. So when we refer to universities, we are talking about those universities which could be creating intellectual property without their knowledge, and what is the potential to capture and to commercialize this technology that is coming out of universities. When we mean commercialization, we don't just mean licensing and making money. Even dissemination of the technology in a way in which it promotes or it helps the society at large amounts to commercialization, because once you disseminate this knowledge, there are others who could get benefited by it and others who could put this to use or even take it into the market as a product. So it's a broad encompassing term. We don't mention commercialization in a way in which it in a narrow way to say that does it bring money into the university, back into the university. It's not that. Now, the entrepreneurial function directly comes out of the research function of the university. Now, we all know that universities have two primary functions. The first function is universities have to teach, that is the teaching function. And the second function, which evolved out of the teaching function, is that universities also engage in research. So the research function is where they create new knowledge, whereas in the teaching function, they deal with existing knowledge. They disseminate existing knowledge. There is no creation of new knowledge per se in the teaching function. But when it comes to research, because they are engaging into activities and into endeavors that could come up with something new, say the research could result in some new knowledge emerging, there is a potential that the products of research could be protected by intellectual property rights. So when you look at any institution which engages in research, that institution has a potential to come up with intellectual property rights. When it comes up with intellectual property right, where the call to protect intellectual property right or to call to protect the products that come out of research is actually the entrepreneurial function of an university. So universities, whether they are aware of it or not, do have an entrepreneurial function. And the entrepreneurial function is directly tied to the research function they have. Some universities may not be into full-fledged research, and some universities may not be what we call, they may not be fully technical at all. For instance, if you are not under the purview of the AICTE, most likely you may not be a technical institute. So, or you take the arts colleges, for instance, or even some of the arts and science colleges. Still, having an measure or having a system to protect intellectual property can lead to a path for them to take research more seriously. So even in that sense, managing intellectual property could be relevant for universities which want to grade up and become or introduce technical courses within their institution. So with this, we had designed this course, Managing Intellectual Property in Universities, and part of the course will tell you about what should be the ways in which you can set up an IP center and what are the functions of an IP center, how does an IP center function, and we would also have a demo, and which we had promised as a part of this course. We will be having a demo of how online IP center can function. So that will come in the 4th week. We'll be having a live session on to show you how institute, which is far away from the main cities where patent offices are, can still get benefited by having its own IP center and file patents and manage intellectual property remotely. Because you should understand that today every kind of intellectual property right can be filed remotely, it can be created remotely, it can be prosecuted remotely. The patent office today allows for video conferencing, and it allows you to answer the objections that come from the patent office by use of video conference and by even without going to the patent office. So when and patents can be maintained remotely. In fact, the patent office today gives more benefits to a person who does a e-filing than a physical filing of a patent. So we can see that almost everything that can be done with regard to patents and intellectual property rights can be done remotely. So I strongly feel that universities and educational institutions can also have an online IP center and manage intellectual property rights remotely. So that was the essence of taking this course for me, because if a country of our size needs to scale up and have intellectual property centers in all the universities, then it will require something which is distinctly different from what others have done in other countries. For instance, setting up a brick and mortar, an on-site IP center could be initially it could be resource consuming. So there should be another more efficient way to do it. So we will show you a demo of how an online IP center would work. We have some questions here. So ideally, the questions, if they are raised on the forum, we'll be quite happy to answer that. So what we will do is we would ensure that if some question is not answered here, we will add it onto the forum and we can take it up from there. Now, there could be an because this is early days in the course. We are just in the second week, and much of the questions, as you have asked here, are covered in the course. In fact, it is covered in great detail in patent law for engineers and scientists, and any question on drafting is covered in patent drafting for beginners, and management issues are also covered in intellectual property, managing intellectual property in universities. There is another course on intellectual property which is just titled intellectual property, which I'm not offering this semester. I plan to offer it in June. So you can, if there is something you need to know about the other aspects of intellectual property, right, like copyright and trademark and designs, that course will be covering that. So I'm going to pick some questions which I feel are not covered in my course, or I feel that it needs to be answered at the outset. Okay. So there is so please give me the discretion to choose the questions. If I'm leaving out some of the questions, it's because it's already covered in the class. You have to be a bit patient. You will be covering it in the class. And if you are not happy or not satisfactory with the answers in the lectures, then you will have to raise it in the forum. I will either cover it in a live session or we will answer it on the forum. So we hope to have more live sessions for the shorter course, that is managing intellectual property in universities, which is only a 4 weeks course. We will be having a live session in week 4. Yeah, and also for patent drafting, we will be having a live session towards the end of the course. The other course is a 12-week course, so we have more flexibility in having more live sessions there. Now, how to plan the study of IP? Now, the study of IP, strangely, is not mandatory. There is no mandatory course, or you cannot get a degree in any of the colleges on IP. So intellectual property right, if you look at the history, it evolved as a recent development. You can see that the World Intellectual Property Organization, which is an organization under the United Nations, was set up only after the 1960s. So it is an organization of recent origin, and intellectual property right itself is a discipline of recent origin. Whereas the other law subjects with regard to criminal law and with regard to civil law, we had a longer history than what we have on intellectual property rights. Now, intellectual property rights became or shot to prominence after India became a party to the WTO, or a member of the World Trade Organization. The World Trade Organization allowed us to, we became signatories to the agreement on intellectual property right, what is known as the TRIPS agreement, and because of which we had to make some local changes in our laws. Now, studying IP, coming back to the question, we need to understand that because it is not being taught as a separate discipline in any of the institutions, and because IP as a subject is taught only in the law schools, I would say that the study of IP has to be engaged while you are doing other things, while you are studying for your other courses, while you are doing your profession. So it is more like a post-qualification study. like most advanced courses that you may do for professional development. So you should look at IP, the study of IP, as a thing that will help you to understand the world better, and these are the things with which the world will be dealing in the future. So we can see where things are heading. Intellectual property will remain an important source of protecting products that come out of knowledge or knowledge based products. And for that, in that aspect, it will be relevant, and the way to study it will be to do it as a part of your existing courses, because almost all IP education today can be obtained without having to disrupt your career or your studies. So the study of IP should be I'll just broadly summarize this. The study of IP should be undertaken as you grow as a professional, either as a part of your study or post qualification. The study of IP should be focused based on the relevance of your domain. If you are an engineer or a scientist, then the kind of IP that will appeal to you is going to be patent. If you are a manager, then you may have to know something about all kinds of IPs, because based on the organization in which you work. If you are a designer, then you need to know about designs and to some extent about copyright, because that is the IP that will be relevant for you. And if you are about creating literary and artistic works, then you will have to know about, or even if you're working in the media, you'll have to know more about copyright laws. So the study of IP, because IP means different things to different people. So based on your background and the field in which you are working, the focus on IP has to change. So I strongly don't recommend that you have to know everything about anything and everything in IP, but rather you should have a broad idea about all the IP, which is a simple course can bring you up to speed on that. And your deeper knowledge should be dictated by the domain in which you are working. And because IP is a dynamic field, and this is partly one of the reasons why we don't have specialized courses offered by institutions. It is so dynamic that it keeps changing and evolving all the time. Even now, when countries are talking about introducing new IPs, even now we are having issues where we have still not found the answers on how IP protection will eventually prevail. For instance, software, patent protection for software, the law is still not fully evolved. Software protection for biotechnology and life forms, the law is still not fully evolved. It is still in the process of evolution. So you will find that because IP is tied to science and technology, as and when science and technology evolves, you will find new issues propping up. What should be the protection for blockchain technology? We still don't know, because the base level blockchain technology is open source, but people build applications on top of it and claim IP protection. It has still not come to the scrutiny of any court. It is not something countries have actually applied their mind on, because the technology is still evolving. So the plan to study IP should be taken off as a part of your professional development, and it should be an ongoing process. And I would say that it is something that will not end, because as and when science and technology develops, there are improvements in human advancement in knowledge. IP will remain relevant. Okay, that's a short answer for how to plan the study of IP. Okay, there's a question on the Berne Convention, and I remember mentioning this in the early parts of the copyright course. The Berne Convention allows any person to have a copyright just by ascribing a copyright notice to it. So if you see most of the websites, at the footer, you will find a copyright notice stating the year and stating that the copyright is owned by a person or by the website itself. Now, the Berne Convention actually removed the need to register a copyright. So understand that every other form of intellectual property right, let it be patents, let it be designs, let it be trademark, let it be geographical indications, you have to register it. Registration is the only way by which you can enforce it. Copyright also has a mechanism for registration, but the Berne Convention allows you to ascribe the fact that you publish it and ascribe a copyright notice. It is deemed to be something that has been protected by copyright. So there is a provision by which copyright is made an exception, wherein the other forms of intellectual property rights that are statutorily mandated or statutorily created patent law, trademark law, and design law, geographical law with regard to geographical indications, require registration. Without registration, you cannot enforce it. You cannot stop others. You cannot get claim for damages or even injunct others through a court proceeding. Whereas copyright allows you to do that. So when you publish an article in a peer-reviewed journal, understand that the peer-reviewed journal will ask you to assign the rights that you have in the article to the journal. This is the norm, because they would want to publish it in different databases, provide this under a wall subscription to various databases. Like your article may appear in JSTOR, it may appear in various other or scientific journals where there is some kind of a payment or a subscription. So for this purpose, the copyright that you have may be assigned to the publisher before it is published. In some cases, this could also happen when you write a book. In some cases, the publisher may allow you to retain the copyright, but then the norm is that the creator gets to keep the copyright. The person who creates is the copyright owner. And before you publish, what you need to know is you need to know the terms and conditions of the website where you publish, which may say that by publishing it here, you are assigning your copyright to us, or they may send you a separate agreement saying that for us to publish it, you have to assign the copyright to us. There are other questions. We have very detailed videos on this. Are there any specific procedure for patent filing for doctors? The short answer is no. The reason is in section 3, there is a prohibition on patenting methods of treatment and surgical methods. So if a doctor, I would presume that the predominant practice of a medical practitioner will be either through surgical intervention or by treating his patients or her patients through medicines. So both these are barred by the Patents Act. A method of treatment or a method of conducting surgery is barred. But an implement that can be used for surgery, a device that can be used for surgery, they are all things that could be a subject matter of a patent. So the core function, as I understand it, of a medical practitioner is to treat human beings either through intervention of chemical substances, medicines, or by surgical methods. Both of these are barred in section 3. Okay, there are some specific questions on lectures in particular weeks. I will skip them because I may not be able to show that right now, because we have 3 courses and there are participants from all the 3 courses attending it. So I don't want to get into the specifics of any course. Now the handbook on patent law is nothing but what we call the Berne Act with the rules. The Berne Act with the rules is essential, and I would say that you cannot do the first part of the course, that is the first course, that is patent law for engineers and scientists, without access to a Berne Act. You simply can't do it. I do show the provisions of the Berne Act, but when you do your own study, you can look at the handbook, and the handbook gives you cross references on the margin, and that's a big development from what you will not get in the market. In the market, you don't get a book, and this was specially designed for people whom I've been coaching over the period of time. So this book will give you, so if you see a section in the margin, you will also find the relevant rule. The rule is mentioned with capital R in front. If there is a form, and you will know that as you do the course, you will become more proficient in using the book. If there is a relevant form, then F is mentioned with the form number. Now, how does this help you? This helps you because if you are planning to take the patent agent examination, the exam will test your knowledge on whether you know how a section is related to a rule and the rule is related to a form, whether you have all these things at your fingertips. So that is one of the reasons why we designed the book with cross references. And the book is much easier to see because it is bicolored. It's easier on the eye. You can quickly find the headings as well. So we can, I think you will be, as you proceed with the course, you will be able to understand how to use the book more efficiently, because most of the videos I'm showing the soft copy of a version of that book. So when you see the soft copy of the version of that book, you can look at the hard copy. The hard copy is much more evolved because the soft copy had some issues and we corrected them. The hard copy is much more evolved, and it makes learning much easier and much more exciting, because it is, you need not now search on your own to find what are the corresponding provisions. It is all provided for you in the margin. Okay, what is the difference between a convention and a treaty? Uh, Largely, they are all international arrangements or international agreements to which parties have signed. So, Berne Convention refers to a convention which happened in a particular place. There is a Rome Convention, there is a Paris Convention, but at the end of it, you know that there is a treaty that parties agree to. So we call it a treaty. A treaty is an agreement which many countries have signed. A convention is a place where people assemble on a particular day and they discussed it. So when you see the convention, they are most of the time tied to a place. Berne Convention, Paris Convention, Rome Convention, whereas treaty is something which is tied to an activity in itself, or a treaty is tied to, say, sometime back we had what you call an agreement on substantial patent law. So substantial patent law treaty. It was called the treaty because the endeavor was to bring together countries and to have a common agreement. That treaty didn't work. So, but it was an attempt to form a substantial patent law treaty. So a treaty is understood as an agreement which many countries sign. Convention is largely, you can use them as coterminous terms, as one for the other, but we understand a convention as a place where countries assembled at a particular point at a particular place. So Berne Convention is actually a treaty on copyright, but the short form is that because there are multiple treaties on copyright. So one way to identify is that when you say Berne Convention, you are referring to a particular treaty on copyright which happened in Berne. How can we establish an IPR cell in an institution? The course will actually, the week 3 and week 4 will have the details on establishing it. Now, one of the reason I offer this course is to tell the universities and the colleges in India that the IP center need not be a room with people in it. We need to understand this. Now, this may sound revolutionary to some of you. Now try to look at the parallel. You have many of the library databases online now. The books which were in physical form sitting in your library can now be accessed on from your rooms, from the student's laptop, or from the professor's computer. Now, in IP, know that every transaction that pertains to intellectual property right can be done online. It can be done online. The patent office accepts online filing. The patent office looks at prosecution, can be done online. You can have video conferences even without going to the patent office, and you can renew and keep every transaction on the patent office can be kept alive online, or can be done online. For this reason, and keeping in mind the growing needs of our country, where it would not be possible for an institution with limited resources and budgets not to start an IP cell, because IP cell could be, depending on the scale in which you want to start it, it could be a resource consuming exercise. And especially in our country, I mean, we now have in the recent examination, that the patent agent examination that was conducted in 2018, we had close to 1,400 new patent agents coming into the profession. Earlier, we had close to 2,000. Now, put together, we still have about 4,000 patent agents in the country. And for a country of our size, more than 1.3 billion, this is simply inadequate. And if we think about an IP center, which has to be an on-site IP center, a brick and mortar IP center, then how many patent professionals are you going to have there? And if all the top colleges absorb patent professionals into their IP centers, what happens to the rest? So I'm convinced that the model of managing IP can be done online, and we will be showing how it can be done online. And because all the transactions on IP can be done online, so just developing on that, we would the model that we would offer for institutions to establish an IPR cell. If the institution has the resource, then they can go for the traditional IPR cell. If the institution has the resource, but it is taking the first steps in establishing an IPR cell, then we would strongly recommend the online model for them. Yes. Um, Yeah. There are some very specific questions. What I would suggest is that we will be having separate sessions for each of the courses. Now you know that this is a joint session for 3 courses, and these are the 3 courses. Just in case you are wondering, and this was done as a means to just bring you up to speed as to what these courses can do. I mentioned at the start of this lecture what is the object of these courses, how they've been designed, what it can do for you, and why you should be doing these courses. Now, we plan to have separate dedicated sessions on for each of these courses where subject specific questions can be raised. I've seen some of the questions there. I would strongly urge you to post them on the whatever I couldn't answer. I would strongly urge you to post them on the forum. We'll definitely answer them. And if you feel that a live session is something that you want, we could also have. We are planning to have a live session in the week 4 for the managing intellectual property in universities, and we could also plan live session for the other courses. I plan to do that more often, but it will be dependent on and getting a common slot which everybody agrees seems to be next to impossible. So we will take a slot and we will do it. Others should be, I think, should settle for watching the recording that will be posted. So that brings us to the. We will just conclude this session, and we will try to ensure that all your questions are answered. But we would want you to post them because I'm not sure whether some of the answers that I've given have actually satisfied you. If some questions remain, please post them on the forum. We have active people monitoring the forum actively, so they will be answering it as soon as possible. And if it requires a more detailed explanation, some of your questions may require a more detailed explanation, then we will be telling you that this question will be taken up for a live session. So thank you so much for joining. This was meant to be a live session where we just told you, gave you a heads up on what is coming up in the course. I know the first week is already gone, but I hope you enjoy the course. And just to reiterate that there have been many people who have benefited from these 2 courses on patent law for engineers and scientists, and patent drafting for beginners. They have actually cleared the patent agent examination, and hopefully they'll be embarking on a career in intellectual property through this. So thanks for joining, and please stay in touch, and please use the forum extensively to communicate with me and my team. And till we have the next live session, this is Professor Feroze saying goodbye to you.